afternoon, Vikas.
Yeah. Those who had attended the previous masterclass by Amrita Salian, partner of Lakshmikumaran and Sridharan, Bengaluru, know the fact that there were concepts which were clarified, which normally just like a cobweb comes in the mind. And today, taking further, we requested her to take a masterclass on venture capital documentation, key concepts under the shareholder agreements. We all know that the topic as such is quite huge, but during such webinars, one can only have short insights, or what we say, a bird eye view. And what is the shareholder agreement and what type of shareholder agreements can be there? These are the facets which Amrita will take us. As we know that she's a gold medalist and she's also advising venture capital funds with investments to her clients in India, Singapore, United States, Mauritius, and her corporate advice on not only on venture capitalism, but it is beyond that. Keeping in view that her previous webinar, not only on this platform, Facebook, YouTube, of Beyond Law CLC, have done very well. And though we had at the first brush itself contemplated and decided that we will have 2 classes on this. So without taking much time, I would request Amrita to take over and take the things forward.
Yeah, thank you, Vikas. Evening, everybody. Thank you for making the time out to attend this session. And because the topic itself, like Vikas suggested, is a little too vast, I don't want to sort of waste too much time in the beginning with introductions, etc. I just want to sort of go straight to my presentation, which I will start very shortly. Sharing my screen. So, the topic that I've chosen today is to discuss basically key concepts under the SHA in the context of a VC transaction. And I'm only going to touch upon the real sort of key concepts without going into too many details about the clauses and how it gets negotiated. You will have some time at the end of this session to basically ask me whatever questions you need, and we can go over those, go over your questions. So what's in store? I basically have what is the shareholders agreement? What is the regulatory framework that you need to keep in mind while reviewing a shareholders agreement? And what are the key concepts under the shareholders agreement? So beginning with what is a shareholders agreement? So we discussed last time in the last webinar on what a VC investment is, the philosophy of a VC investment, etc. We spoke about the SSA, which is the share subscription agreement, and what that agreement sort of captures. The second document, the second key document that is very important in a venture capital transaction is the shareholders agreement. This is usually signed together with the share subscription agreement, but it comes into effect on the date when the money comes into the company and the investor is allocated shares. Okay, only when the investor becomes a shareholder in the company will the provision of the shareholders agreement apply to that investor. Although the execution date can be the date when the SSA is signed, that is the date when the venture capitalist agrees to put in money into the company. So a shareholders agreement by its very name is very clear. It's an agreement between the shareholders of the company that basically governs the rights and obligations of shareholders vis-a-vis each other and vis-a-vis the company. In the context of a VC transaction, because the investor is putting in money into the company, the investor gets most of the rights. Most of the obligations are mostly on the company and the promoters, or maybe some other shareholders, because sometimes, depending on the series of venture capital investment you're in, you can encounter other angel investors, other seed investors. They can be institutional investors depending on the series. And usually, when you draft the SHA, you consider whatever rights has been granted previously and sort of marry the rights together with the new investors' rights and draft it up. If it's a fresh SHA where it's only a startup and the first time as a fundraise, then you basically, it's only between the promoters and the company and the investor. So, I mean, if you have to break down the concept under the SHA, really there'll be 4 or 5 only. First thing is as I mentioned, when do you sign this document? And I hope that is very clear to everybody. The second thing is the purpose of replicating the provisions of the SHA into the articles of the company. There's a lot of case law and a lot of debate going on this. There are three primary cases that one needs to be sort of aware of, three or four actually in recent times. One is the Supreme Court's judgment in the Rangarajan case. The second one, there's also a Supreme Court judgment very recently in Vodafone case, which sort of looked like they were overriding Rangarajan. There's a Bombay High Court judgment, and there's a judgment of the Delhi High Court. I don't recollect the name of the case, but it is Justice Muralidhar's judgment on the SHA, and it makes for fascinating reading as to why you need to replicate the provisions of the SHA into the articles. Now, I think the simple principles are as follows. If you read Companies Act says that you can't, articles or the provisions of the SHA cannot override what the Act itself says. So you cannot have a provision that is violating the Act. Similarly, Companies Act also, Section 10 says that every shareholder is under an obligation to sort of abide by and comply with the provisions of the articles. So I think there are two or three things that people or lawyers need to remember in this context. One is that whatever you agree in your SHA for enforceability purposes, depending on these case laws, you have to put it into the articles. Otherwise, you may be in a position where you can't really enforce the right? And what kind of enforcement are we talking about? So the SHA is basically a contractual agreement between parties. So if there's a breach of the SHA, you have remedies for breach of a contract under Contracts Act as a regular contract. So you can claim damages, you can claim all the other stuff that's available for breach of contract. The Articles of Association of a company, on the other hand, is basically something like you can call it a statutory contract between the company and its shareholders, which regulates the running of the company, as in how will the shareholders board meeting be held, etc., the rules for that, and any other rights that the shareholders have inter se each other. So really the difference is one is a contractual agreement, the other is a statutory contract. So if you breach the articles, you have better rights in terms of enforcement as opposed to just damages under SHA or contractual or rights for breach of a contract under the SHA. So that's the essential difference. And now it's a settled position under Indian law that, and most transaction lawyers will be aware of this, that people usually replicate the entire provisions of the articles into the SHA for better enforcement purposes. The second concept is who are the parties to the SHA. Like I mentioned, a lot of people make the companies also a party these days. Then there's the promoters, and there are all the shareholders of the company, who be it investors, depending on whatever kind of investor. So basically, essentially, most of the shareholders are parties to the SHA. Now, if you have to break down the SHA itself without making it very complicated for anyone, it falls under three broad heads. One is governance rights. Governance rights basically means rights such as board seat, or the rights that you have in connection with the board meeting, shareholder meeting. And we'll go into a lot of depth on that in the next slide. Second broad head is a transfer right and restrictions. So there are certain rights in which, because the investor has put in money into the company, he'll also regulate how the shares are transferred, right? Because if put yourself in the position of an investor, you would want to know who sits on the cap table. You want to know that the promoter of the company that you've invested in, because the investment is made in the company and in the promoter's track record. You don't want the promoter to sell off the company someday and so that you have no rights against, or you're stuck in the company without a promoter. So that's the reason why people have or regulate the transfer rights and restrictions. The restrictions are mostly on the promoters and maybe small minority shareholder shares. And it's always a right that the investor has. There are usually no restrictions on the investor's transferability, except probably one exception, that is transfer to competitors. And we'll speak more about that in the next slide. And the third broad bucket is economic rights. Economic rights are rights which enable you to get a certain amount of money at the sale of shares. For example, if you put money into the company, how do venture capitalists make money? They make money through selling the shares off by getting a good exit, right? Everybody's heard of exit as a concept. So essentially, the way venture capital funds work is they put money into the company. They have a certain period within which they want to leave the company, as in they want to sell their shares and make money off it. So if they put money today they buy a share at 50 rupees, they want to be able to sell it off at 5,000 or more than the price at which they bought it, right? So that way they can get 2x, 3x, sometimes even 10x or sometimes even 50x returns. And that's how the venture capitalist makes their money. And so the rights that you negotiate in the document to give them the right to exit and to protect their exit right is called economic rights. So those are the broad buckets or the broad concepts that you'll have to keep in mind while sort of reviewing a shareholders agreement. Moving on to regulatory framework. Now, the regulatory framework is very, very simple. It's exactly the way it is under the SSA, that's a share subscription agreement. Like I said, first of all, you need to understand Indian Contract Act. You need to understand what are the remedies you have if you breach the SHA under the law, and contractually, what can you agree to? Second of all, you need to understand the Companies Act and the provisions in there, because there are provisions on what you can do for board and shareholder meetings, how you can structure your AVM rights, etc. How you can enforce some of the key rights of the investors. And obviously, you cannot agree to anything in the SHA which contravenes the Companies Act, because that will simply be void. And the third aspect is most of the funds most of the funds sort of use vehicles to invest in which are outside of India. So most of them, most of the times, it's money coming in from outside of India into India. That's why you'll have to look up the non-debt rules or the FEMA regulations, the applicable FEMA regulations for these kind of investments. You need to keep in mind specifically the sector in which the investment is made, and if there are any conditions attached to that sector. If there's something that's prescribed under the circulars that needs to go into the SHA, you need to be mindful of it and make sure that you structure your SHA accordingly. For example, in the pharmaceutical sector, no non-compete is allowed, right? So if non-compete is a very sort of standard provision in an SHA to protect the investor's interest and to make sure that the promoter doesn't set up a competing entity and doesn't sort of divert all his attention to that entity, and basically to incentivize the promoter to stay back in the company and run the business. Because investors are not, especially VC investors, they're not equipped with, or they don't want to be in the position where they have to run the company. That's not the philosophy of the investment. They want the promoter to run the company, and they just want to be a partner in the journey. That's all. I mean, they want to be partner at a very high level. That's why VC transactions are structured in a particular manner. That's one thing. The second thing is sometimes even enforcement of rights of an investor is subject to, of course, the law under FEMA. For example, those of you who are familiar with the non-debt rules will know that you cannot give an assured exit to the investors anymore. This is regulated by FEMA. It was a recent change to FEMA. So that means there were a lot of times previously, about let's say about a decade or 9 years back, when people used to have the concept of the exit price would usually be a percentage. They would say, give me my investment amount plus also give me a certain percentage, right? I mean, on my investment amount, that should be my exit amount. And if you don't give it to me, then there are consequences for it. So basically, to prevent that kind of scenario, it's called the IRR, internal rate of return. To prevent that kind of a scenario, it was, I mean, there was this provision in the FEMA that was introduced that basically said you can't give an assured return. So you must know provisions under Companies Act, and you must know your FDR rules and regulations to make sure that you're structuring your SHA in accordance with those rules. I'm going to move on to the key concepts under the shareholders agreement. And here, like I mentioned, I've just put it out into broad buckets. I'm just going to put out everything and then sort of go into the deep dive. Okay. So if you divide the concept under the SHA, like I said before, it really will be under four broad buckets. The first bucket you're looking at is the governance rights. And what do we have under the governance rights? So you have the concept of a board and observer right. This basically means that, and every time an investor comes into the company, the investor will ask for both a board seat and an observer seat, or may ask for just one of them, depending on the amount of money that's put in. So this is directly related to the percentage that the investor will finally hold in the company. For example, it's very standard. It really depends on how well the negotiation goes on between the investor and the promoters in that sense. A lot of people get both seats at 10%. Sometimes they get it at 5%. An observer right is basically a right where it's where you're not a board member of the company, but you're You just are given access to certain information rights, information relating to the board, and you have the right to be present in a board meeting without participating in it. Why is that important? Because there are some sectors which are considered high-risk sectors. For example, let's take an example of real estate, right? You can take an example of co-working space, for example. There are some laws, some local laws under which the liability in the directors is very high. And you must remember that when the investor comes on board, the idea is that the investor will not be an executive director. It'll more likely be a non-executive director with limited liabilities. That's what you'll agree to contractually, but the law is a completely different ballgame. So sometimes if the liability, especially when there are a lot of criminal liabilities associated with local laws in a particular sector, people tend to prefer to use the observer seat rather than use a board seat and be on the board, although they'll negotiate for it, but they won't appoint a board nominee. So that is a concept of a board and an observer right or seat. The next one is quorum rights. Quorum basically is, in simply put, meaning in both your board and shareholder meeting, the investors usually negotiate a right which says that you cannot hold board or shareholder meetings without the investors' representatives being present. That's called a quorum right. So to form a valid quorum contractually, you will need the presence of the investor's representative. That's the simple concept of it. The SHA will also go into how the board and shareholders meeting must be conducted, how many days notice you'll have to give. What are the kind of reports you need to give before the notice is given, etc. And this has to be drafted keeping in mind the Companies Act provision. There's no point in putting in something that sort of is contrary to the Companies Act. So it must be drafted very practically and keeping in mind how, so long as the drafting is in compliance with Companies Act, and unless if you're representing an investor, unless your client needs some time to internally organize things, these things are never usually sort of recommended, never negotiated. The last concept and the key concept there is affirmative voting right. Affirmative voting right is more a protection right. It basically means it's like a veto right. It basically means that there will be a list of matters that the company or the promoters cannot take any action on unless they get the consent of the investor in writing. The procedure of it also will be set out, and this for both investor councils and company council, it's better to do it very practically. I know a lot of enthusiastic lawyers. See, this is like a VC investment. It's not an investment, and you must understand the philosophy of how the VCs function. They're not interested in the day-to-day activities of the company. They're only interested in things that affect their exit or affect the indebtedness of the company to a large extent. So the matters that you curate into this list should be specific matters, because this will come to the investor every time, and you don't want it to become an administrative nightmare for both the investor and the company. In terms of there should be enough space for the promoter to run his or her show without having to go to the investor on every small thing. So this list should be kept in mind. You should just make sure that you only put in essential things there, thresholds and the numbers that you put in there. I mean, it's very typical to see saying that you can't raise debt beyond a certain amount. You'll put in an amount. Don't negotiate for paltry amounts. Put in something that's substantial, that affects the company in general, and that therefore affects the investor as well, because that way you'll make it procedurally less cumbersome on both the parties. So that's the concept of an affirmative voting right. It'd be very interesting. Those of you who are interested in doing further reading, you should read up the Companies Act jurisprudence on affirmative voting right, especially vis-a-vis board matters, right? Where sometimes in the past we used to divide it into board matters that need board consent and matters that need shareholder consent. It's not done anymore like that these days. It's directly all the matters that are, it's just one bucket of matters, whether it's board or shareholder. And there are interesting case laws on whether, the enforceability of these things, especially given the fiduciary obligation that a director has towards the company. And whether you can, whether while enforcing affirmative voting right, people end up sort of compromising on that fiduciary obligation. So there are interesting case laws on this. You can sort of read up on this more if you're interested. That finishes the governance rights. We come next to the transfer rights and restrictions. Transfer right and restrictions are basically, these are all concepts in terms of how, what kind of rights or obligations you have in respect to transferability of shares. The first one is basically lock-in and clawback on promoter shares. It's very common for the investor to say that the promoter cannot, especially in very early stages of investment, to say that the promoter cannot sell his or her shares without the consent of the investor, and for a certain period of time. Okay. Sometimes there are exceptions saying you can sell up to a certain percentage for estate planning, or if you're doing an interstate transfer between two or more promoters. So those things can be negotiated, but it's the reason and the logic for this is because people do not want the promoter to sell off their shares. I mean, a good company, like I mentioned, I mean, these investors are not there to run the company. They're there to partner with the promoter to help the promoter build the company and to meet his vision, his or her vision, right? So they don't want to be in a situation where the promoter sells off his shares massively, or is not interested in the company anymore. And that's not a pretty situation for them, because you need somebody to run the company. In very advanced stages, it's very common to see the promoter shareholding drop. But that's in advanced stages where people have comfort with the promoter. They know commercially why people are doing this. But the simple concept of a lock-in is to ensure that the investor is comfortable. And this is usually in very early stages. The investor is comfortable that the promoter is not sort of massively diluting or selling off shares without investor consent. Then you come to about 3 key transfer restrictions. One is the ROFR, it's the right of first refusal. The other is RO4, which is the right of first offer. And the third one is called the tag-along right. It's also called the co-sale right. So let's pick ROFR first. The right of first refusal is basically a right. It's a right that an investor has, and it's an obligation on the person on whose shares the ROFR applies. Okay. As the name says, it's right of first refusal. It basically means that let's say there are two parties. It's usually on the promoter shares or some other shareholder shares. Let's say there's investor A and there's promoter. If the promoter wants to, first there'll be the lock-in that applies. If he or she wants to sell shares, they have to go to the investor, get consent. Okay. Second is, if there's a ROFR also, what happens is it's most likely, the difference between a ROFR and a ROFR lies in this concept. So basically, it's most likely that the person would have already identified a third-party buyer, whoever wants to sell, the transferring shareholder. Okay, would have identified a third-party buyer, would have basically figured a price also for transfer of share. And then what's going to happen is then going to come back to the person who holds the ROFR holder or the investor, and say, look, this is a person who's willing to buy my share at this price. Do you consent to it or not? You need the consent of the investor before you can go ahead and sell that share. Okay, that's the simple concept of a ROFR. And the investor has a right to, if the investor says no, they also have the right to purchase that very share by matching the price or putting a higher price to the share than the third party buyer. That simply put is a ROFR. It's a little bit of a problem in the sense, like, I'll tell you what the flip side is. For a lot of, especially when you do secondaries, right? Secondary transfers, as secondary meaning as transfer of shares. A lot of buyers, the minute they see a ROFR clause, will not even be interested in buying the shares. The reason is as follows: unless there's excellent equation between the promoter and the investor, because you would have put in all the effort to do the price discovery and figure out a price, etc. And then the investor can come around and say, I don't want you to, I'm sort of not consenting to the share to be sold out, right? So it can be blocked by somebody else. And that's the reason why people, it's a very common clause to have. There's nothing to sort of worry in the sense while negotiating this, because it's very common, especially in early stage investments. But that's really the only disadvantage that's there, and that can be easily managed. Most venture capitalists are very sensible with the way they sort of deal with their investment and the portfolio companies. They don't unreasonably sort of withhold consent unless there's a strong commercial reason to not do so. A RO4, or a right of first refusal, on the other hand, is more a price discovery mechanism. The difference between a right of first offer and right of first refusal is that when you're exercising a ROFR, you may or may not have a firm offer from a third party buyer, right? So you just come, you just say that I'm shopping around. I have some interest from some other sellers. What is the price that you are willing to offer? So you go back to the investor and say, I want to sell, and what's the price that you're willing to offer, right? So it's more a price discovery mechanism. The procedure remains the same. I mean, usually if you understand the concept, the procedure is something that's just the way these rights will work, in the sense that how many days notice you'll have to give, what are the details you'll have to give, etc. There's nothing more to it. The tag-along right, on the other hand, is a right that the investor has. It basically means that if the promoter is selling, or any of the transferring shareholders are selling the shares, the investor also has a right to sort of together with to sell their shares. To sell the shares together with the person who is transferring the shares. So let's say there's a promoter holds 10 shares, investor wants, and the promoter wants to sell the shares. The investor will say, I'm okay with you selling the shares, provided you give me also the right to sell along with you. I also want to sell 10 of my shares, right? So it becomes very useful sometimes to have this right, because if there's a need for the promoter to sort of sell the share, and the investor also wants to sort of sell along with the promoter to make sure that they don't overtly dilute. And this is a good and useful right to have. Usually this is standard. Sometimes it's drafted together with a ROFR, so you don't exercise your right of first refusal, but you exercise your tag-along right. Every standard SHA will see this. So there's nothing to. It's something that very commonly found in most VC transactions, in most SHAs. The one thing you'll have to remember is how much of a right in all these three things, right? To what extent can the investor sell his or her shares? I mean, can they sell it? Is there a full tag? Is it even the ROFR? To what extent? So it's usually a pro rata right, meaning if the promoter sells 10 shares, then simply put, the investor also will be able to sell 10 of his shares. That's called a pro rata. I mean, basically pro rata to the sale of shares that happens from the promoter side. Sometimes there's also a full tag, which basically means that even if the promoter sells one share, the investor will have the right to sell 100% of. It's a right, but not an obligation. So they can choose to sell up to the full extent of the shares, or they can choose to retain just, not sell. So you must remember that as part of these rights. A right only means that you have the right to do it. You can choose not to do it. There's no obligation to the person holding these rights. The next thing is restriction on transfer to competitors. This is an important concept. This is probably the only restriction you'll find in the SHA on investor shares, because otherwise it should be freely transferable. Mostly, unless you're in a very advanced stage and there are strong commercial reasons for having restrictions on investor shares. This simply is where you restrict the right of an investor or any other shareholder to basically sell to a competitor. This is mostly a right that most promoters ask. The only negotiation point is who will be a competitor. It's usually put out as a list in the schedule to the SHA, and it's down to about 5 or 10 names, depending on the sector that they're in and depending on the comfort of the investor. The investor will probably max to max agree to something like that, and a broad definition usually doesn't work. I've not seen it very often in VC transactions, unless it's a very advanced stage and there are many considerations there. But mostly it's down to a list of few people who will qualify as competitors, and there'll be restrictions on those transfers to those competitors. Basically, meaning that you cannot sell it unless you get consent. Deed of adherence is the next concept. A lot of you will see this in a standard SHA. It's basically a deed or a document. It's a one-page document that needs to be signed every time there's a transfer. It's usually done so that you don't have to reinvent the wheel. In terms of whenever there's a new person who comes on the cap table, that person will or comes into the company, you transfer, that person will essentially replace the old shareholder, right? So you need to make sure that that person is also complying with the provisions of this SHA. So the simple way to do it is, instead of running the entire SHA past that person and going through a roundabout negotiation, you just have a one-page document. It will basically say that the rights that the transferring shareholders will give to the new person or the new buyer, and there'll be a clause that says that they'll comply with the SHA in fully. So it's just a simple one-page document that it's more to basically simplify the procedure and to make it more simple. That's something that will be a condition. Essentially, you need to look at it to see that there's nothing cumbersome that's put out there that restricts your transfer. It should only contain the basic thing, that the rights that are being transferred to the new person, how that will be exercised, especially if a shareholder has 50 shares in the company, is only transferring 25. What are the kind of rights that this existing shareholder will continue to have? And what are the kind of rights that will be transferred to the new shareholder? That's one thing. And you just need a covenant that the new shareholder will comply with all the existing provisions it's comfortable with, has had a chance to read the SHA, and will comply with all the provisions under the SHA. So that's the concept of a deed of adherence. Now we come to the more mathematical clauses, the economic rights. So like I mentioned, every investor that puts in money is hoping to someday sell those shares and make money. So the exit right is basically a right that you give to the investor. It'll broadly have 3 or 4 things that you need to cover. One is the exit window. For example, how long does the investor have to stay in the company till the time this right kicks in? Mostly in VC transactions, people stay anywhere between 5 to 10 years. And just because it's 5 years doesn't mean that at the end of 5 years, the company or promoter has an obligation to provide an exit. Sometimes the company is doing well, the investors are happy to stick along for a longer time. They may exit, they may sort of increase the exit window to how many ever years, because the company is doing very well, the valuation of the company is going up, which means that the returns that they're going to get when they sell the shares, that's also going to be increasing proportionately, right? So 5 years is a standard exit window for most investors. They start with 5 years and then it goes on. You can either increase it. Mostly it can never be decreased because you're agreeing to it upfront, saying that it's going to be 5 years. What does it imply? It basically means that after 5 years, there's a direct obligation on the promoters to ensure that an exit is provided to the investor. Okay. And logically, if that is the thing, how do they provide exit? So that's the second thing that is documented in an exit clause. Usually exits are provided by way of IPO or a trade sale. These are the 2 main ways in which you do it. IPO is basically where the company lists its shares. And when the listing happens, the investor can then sell the shares of the listed company, make its returns and move on. Trade sale is where you find a buyer to buy majority shares in the company, including the investor's shares. That way you negotiate with the buyer and get a price that the investor is happy with. So that's that. In addition to, so these are the 2 rights, right? And there's a window within which the company must, or the company and promoters must basically facilitate this exit. But the third concept is at what price should the shares be sold? You also document that, and that's called the exit price. Exit price basically means that the promoter and the company are in an obligation to make sure that they give an exit to the investor at a certain price. So this is the clause I was talking about where there are FEMA implications. Most people, because of FEMA and the way it's drafted under the non-debt rules, because you can't give an assured exit to an investor, it's usually drafted as higher of FMB or 1x. 1x is basically your basic capital. If you put in 50 rupees, you expect to get back 50. Or FMB. FMB is basically fair market value for that particular share. So usually this is drafted like this these days because of the restrictions under FEMA. It's usually down to FMB. Whatever is the fair market value at that time, you take that price and you move on. Earlier, there used to be people who drafted IRRs as an interest, saying that if I put in 50 rupees, I need 50 rupees plus I need a 13% interest on it. So I will not agree to an exit unless I get back a certain amount of return. And that's what is called assured return. And the reason the RBI cracked down on it was because they felt that if you have an exit return, if you have an assured exit price, it basically means that it's no longer equity, it's debt. Because only in debt instruments, like in loan, you can say that I'll return it back with a certain interest rate, right? Otherwise, you shouldn't be returning back. Equity is risky. And that's why the philosophy of equity investments are different compared to debt investments. That's the concept of an exit right. Now, the other concept you have to remember in connection with the exit right is the exit default right. What does it mean? It basically means that if the company and the promoters have failed to give an exit to the investor within that particular exit window at that particular price, the investor has some exit default rights. And usually these rights are third-party, the right of the investor to ask for a third-party buyer to basically come and buy their shares. So the way this clause will work is the investor will give a notice to the promoters of the company saying that I want to exit, find me a third-party buyer. Okay, and then it's the obligation on the promoter or the company to basically go back and find such a third party, right? And make sure that the sale happens for the investor shares. Or they'll do something that's called a drag along right. Now, drag along is basically the right that the investor has and an obligation on the people who can get dragged. A drag basically means that the investor has a drag along right. He has the right to say to the promoters and the other shareholders that, look, I have a buyer in mind. I want to sell my shares to this buyer. The buyer, however, wants to buy the entire company, not just my shares, but the entire company, right? So then the other people who are the drag shareholders are under an obligation to sell all their shares. The minute the investor drags, the others will get dragged, and they are under an obligation to basically sell the shares. This is just there as a protection provision for the investor to make sure that if they don't have an exit, they'll probably, I mean, in my entire career, I've never seen a drag being enforced, or they don't usually resort to this, especially in a VC transaction. But it's just there for protection purposes to make sure that there's some sort of a protection or some sort of leverage under the document for the investor in case they're not getting an exit, or it gets so acrimonious that exits are getting blocked. Now, when there are multiple investors on the cap table, usually this is given as a joint right to all of them. It's in the company's interest to have, if you're giving away a drag right from a company perspective or a promoter perspective, it's in the company and promoter's interest to give this on a joint basis to a bunch of investors, because then you know that it has to be a joint decision and it's not at the whims and fancies of one investor generally. And people will be sensible. A larger group will be more sensible rather than one person having this right. That's simply put, that's the exit right. These are the concepts that you remember in connection with an exit right. The second economic right is a liquidation preference. A liquidation preference basically means that if there are certain events that happen in the company, okay, which are called liquidity events or liquidation events, then the investor has it, and if the investor sells his shares during those particular events, then the investor has the right to get a certain amount of money, okay? So a couple of things you'll have to remember here. One is, when will this clause get triggered? This clause gets triggered only if there's a liquidity or a liquidation events. Now, it's supposed to be something that's called downside protection, okay? For people who are not familiar with this term, it basically means that if the situation is not that great, if the company is not doing that well, there's a winding up of the company that's happening, or whatever that's happening, right? Something that is not a very nice situation. The investor wants to make sure that they actually are able to pull out at least 1x or the principal amount of investment that they made, nothing more, right? If there's something that's happening in the company that's not a favorable situation, they want to make sure, and they have to sell their shares, and that under those circumstances, or this, they want to make sure that they actually make at least the basic investment amount. So the liquidation preference amount is usually drafted as higher of 1x or pro rata. Pro rata basically means that if you hold 25% of the company, you get 25% of the share of the sale proceeds. That's what pro rata means, and it's usually whenever you draft it higher of 1x or pro rata, you end up usually sort of mathematically, it makes more sense to do pro rata calculations rather than do 1x for some people and do pro rata for the other. It's more math. So that's a concept of a liquidation preference amount. Now, when does this get triggered? It gets triggered, like I said, on the liquidation event. Now, when you draft an SHA, when I was saying it's downside protection, that means you're only supposed to have circumstances where things like winding up, things like winding up or change of control, things like that, right? But people usually also put a liquidity event in there. Liquidity event is any event that enables you to sell your shares. So usually a liquidation preference clause will have, or a liquidity event will have winding up, it will have change of control, it will have merger, consolidation, anything that any event like that, which ensures that the existing shareholders retain less than 50% of the shareholding in the company. Sometimes people even put in an exit. People put in drag along right. So, and which results in a little bit of a double dipping for the investor. But as a concept, it's only meant to as a protection clause to protect the investor from a situation that's not that great, and to enable an investor in that situation to actually contractually at least pull out the basic principal amount that the investor has invested in the company. Simply, that's the concept. It gets more complicated when people add things like exit, etc., because you'll already be making money out of there's already an exit price at play, and you don't really need this clause. But it works in a way where you can probably prevent some of these events from happening if they don't give you a certain price. For example, if the promoter wants to go ahead and do a merger or a consolidation or some other corporate event which does not give you a basic price, right? Then you can use this clause to basically say that I won't waive away my liquidation preference right here. And you have to make sure that the price of this is favorable for me. The price at which you're doing the merger or price at which you're doing the consolidation, etc., is favorable to me. The other thing to remember is every investor that comes in, the liquidation preference is given to the series of preference shares. So there's usually a waterfall, right? The SHA will have a waterfall which says that if there's a liquidation event or a liquidity event, the first people to get paid off will be series, the last series, series C or C. If you're in the series D guys will get paid off first, followed by the series B guys, then the series A guys, however you negotiate it. So there's typically a waterfall, which the waterfall basically means that you need to, it's just the order in which shareholders will get paid off their liquidation preference amounts. The other key thing to remember is nobody can claim a liquidation preference amount. No investor can claim it unless they sell their shares. So it's not like, and your drafting should reflect this logically, because unless, how will you account for that money, right? If you're not selling your shares, it's basically meant as a price associated with the sale of shares under certain circumstances. So it's a little bit of a complex sort of a concept. But as you familiarize yourself with more math, and as you get familiar with this concept, you'll understand how it sort of works. That's liquidation preference. And the last bucket is key provisions, other key provisions. Under this, we have, first one is the concept of a preemptive right. A preemptive right is basically the right that's given to an investor, where the investor has a right to participate or put more capital into the company when a new fundraise is happening. And usually this is a pro rata right, which means that pro rata to the investor shareholding, the investor will have the right to also participate in the next round and put in more capital. This is useful for the investor because they can maintain their shareholding that way and prevent themselves from dilution. Sometimes, unless they, the early stage investors, for example, if they have 10% in the company already, there's a new person coming in who will get 20% of the shares. Mathematically, the promoter shareholding and the 10% shareholder shareholding will come down because of the new person who's come in and who's going to hold 20%. So this clause sort of gives right to the investor to basically also put in some money, put in just enough money to make sure that they, on a pro rata basis, maintain their shareholding in the company. So and the rest of the clause will usually be on the procedure in which this happens. The next concept is anti-dilution. Anti-dilution, as it basically means that if there's ever a situation where the investor has come in at 50 rupees, has paid 50 rupees per share, okay, for its shares, and then the next round happens and the new investor gets the shares at 40 rupees. There's a difference in price, right? People are not, usually it should go upward. If the first round is at 50, the next round should be at 100 or 50 plus. It should never come down because that would result in dilution, which means that the new person who comes in will get more shares for less price, right? It will obviously dilute the existing shareholders. So what the investors negotiate is they negotiate an anti-dilution clause. They basically say that if you are doing that, if you're giving shares or issuing shares to a new person at a price that's lower than mine, then you need to compensate me for it. How do you do that? There are two ways. You can either do it through something that's called the ratchet method or something that's called the weighted average method. There are only two ways to do it. They're both mathematical formulas. And if you want to understand as a concept the difference between the two formulas, ratchet basically means that the minute there's a new round at a price that's lower than the previous round, shares will be issued to the investor, or there'll be an adjustment to the price of the old round to the new round. So let's say if 50 rupees of the share in which 50 rupees was the price of the shares that an investor purchased, right? The next round comes and the price goes down to 40. The calculation will work such that you'll probably have to compensate the investor with more shares, such that as if the first investor who purchased at 50 has purchased those same shares at 40. So essentially, it's a huge amount of it's more burdensome and cumbersome mathematically on the promoters in the company, which is why a lot of investors and promoters, and the standard practice that most people follow is something that's called the weighted average method. The weighted average method, instead of resetting the price completely to the price of the new round, it considers the new round price, and there's a formula which you use to basically arrive at how many shares you'll have to compensate the investor. And the number of shares that you probably arrive at from the weighted average method will be lesser compared to the one that'll be under the ratchet method. So basically, most people, ratchet is usually not used anymore unless it's specifically negotiated and for whatever reason the promoter council or promoter has given it away. It's usually broad-based weighted average, which is a formula and which is very standard. And you can probably, the many ways in which anti-dilution is enforced. One is by way of issue of fresh shares at a lower price. Sometimes people do it through bonus issuances. The other way to do it is through conversion, tampering with the conversion formula. And that's the third concept. Conversion is basically a term that you would see in the terms and conditions of CCPS. Most CCPSs have 1:1 conversion when you start off with. It basically means that for every CCPS, CCPS you hold, that CCPS will convert to one common share. Okay, people make adjustments to this formula. So sometimes 1:1 becomes 1:0.5 or 0.75, depending on the anti-dilution adjustment or mechanism or the number that you've arrived at based on the mathematical formula of the weighted average. So you sort of do that. Sometimes what you will also see in conversion is, instead of seeing a ratio, you will see a price. That will basically be the subscription price. So if you bought the shares for 50, the conversion price would be 50 rupees to start off with. And that 50 rupees, if you make an adjustment, it will probably be lowered down to something else, or it will go higher up, something else. If you adjust the conversion ratio, which basically means that you are entitled to more shares. So that's one way. That's the concept of conversion. Then you have the concept of non-compete and non-solicit on promoters. The logic for this is very simple. Naturally, you want every investor would want the promoter to run the company, would want the promoter to say invested in the company, and not to set up another, once they receive funds, not set up a competing entity with a transfer business and make that profitable, instead of sort of putting the efforts into the company in which the investor is invested. So it's very common for people to have a non-compete clause in the document. There's also non-solicit. It's more protection clauses for the investor. You just have to make sure that the provisions of the law on contract or non-compete, as well as the provisions sometimes under exchange control regulations where non-competes are expressly prohibited, those things are documented for and accounted for in the SHA. When drafting the SHA, you need to make sure that it's something that can be enforced, because there's no point in putting in something that's contrary to the law. The other concept is one of event of default and the consequences for event of default. An event of default is basically a situation where the promoter or the company has defaulted on a certain circumstances. You usually have a definition for this. You'll say that you'll define events of default to mean XYZ things, right? And if the promoter or the company has done something that falls within the definition of an event of default, then the consequences for event of default kicks in. You must be very careful. The concept of this is to basically, it's not something where every breach should be considered as an event of default. Event of default should be looked at from a provision where it's something that's irreversible, or something that's so it's so fundamental that the investor can no longer stay in the company, right? You will have to remember that when the shareholder agreement comes into effect, the investor will be a shareholder in the company, meaning investor has shares in the company. So a lot of times, that's why you'll see most shareholders agreements, some of them at least, will not have indemnity provisions, or if they have it, it'll be under an event of default clause. The reason is why you can't be in a situation where you have shares in the company and your equation with the promoter is not okay, or you start doing indemnification, or you start enforcing an indemnity, right? Because that means you've reached an acrimonious situation. It means you're basically suing the person who's supposed to run your company while you're there in the company, right? And then it gets very nasty thereafter. That's why people usually have event of default clauses, and this is only supposed to cover a lot of sophisticated investors only keep it to things like fraud or offenses involving moral turpitude, or where there's an irreversible sort of non-bailable or non-appealable arrest warrant against the promoters. Those kind of situations are the situations in which this particular clause is invoked. It's not supposed to be for petty breaches, which can actually be remedied. Sometimes you even have things like material breach, etc. But really, once you put your money into the company, you're also a shareholder in the company. If the company does well, you do well. If you start dragging the company to courts and make an issue out of it while you're actually devaluing the company, right? So that's why it's only kept to limited set of circumstances under which the situation really is irreversible, or where you can no longer continue in the company as a shareholder. And naturally, the consequence would be something which involves the sale of shares, because simply having indemnity will not really work. It'll only be people fighting in the courts of what happens to the shares of your company, right? So mostly the consequences are drafted by way of put options, or they're drafted by accelerated exit clause. What does it mean? Put option basically means that it's where the investor puts his shares or gives notice to the promoters in the company saying that I want to sell my shares and you buy it, right? That's a put. They put your shares and the obligation is on someone else to sort of buy it. There are also things like buyback, which comes with its own implication on the Companies Act. Or you can say that even though my exit window is 5 years, I want to accelerate my exit, as in I want to exit before my exit window, because I can no longer stay in the company. So all the exit rights that you have will be accelerated as a consequence. You can also, for a good measure, have indemnity in, but nobody just uses indemnity. They use a combination of these things to basically get out of an event of default situation. And like I said, it's only reserved for, the way you should view this is, you should view this as a situation that's massive enough, where there's a lot of fraud that's happened that you cannot cure it, or the promoter, there's an sort of a criminal liability that's not appealable. And anything that devalues a company, it makes it difficult for the investor to stay in the company. That's an event of default, and the consequences will be as I explained it to you. Then there are provisions like inspection and information rights. These are basically rights that are given to the investor. Information right is something that an investor may sometimes need, because they will also have LPs or limited partners who have invested in them in the fund itself, and they need to give information to their LPs on a regular quarterly basis or a regular basis. And that's how whatever the information they need from the company is where whatever the information they need from the company on a regular interval is what is put out here. And it's mostly drafted from the point of view of what the investor needs to make notes, or to sort of keep a track of the progress of the company, or what they need to basically make as a presentation to their LPs internally. There's also a catch-all provision, which will be any information reasonably requested, and that is mostly used it'll be more relevant in a dispute situation, where there's a dispute going, or the investor suspects something is going, and they'll probably trigger this information right to basically say, give me this information. Inspection rights also become more relevant. It's basically the right of the investor to inspect the books and accounts and premises of the company. Usually you give this right on a yearly basis or a half-yearly basis, and you decide who will bear the cost, etc. Most investors don't even these clauses don't even get triggered unless it's an extreme situation where there's a dispute or something that's come up, and you need these provisions. And these are very helpful provisions in a dispute scenario. The final thing I wanted to touch upon was termination. And this needs to be just like you draft most of the other contracts where you say termination will occur on breach. That's not how a termination clause from an SHA should be drafted. The reason is you have to remember that you have shares in your company, right? You have shares that are still there, and you should not be essentially you should not be what do you say? I mean, you should not be basically terminating the SHA without selling your shares. So the logical conclusion then is SHA terminates when you've sold all your shares. That means you're no longer a shareholder in the company. Or when there is, so basically when there is, when the IPO happens, because IPO rules require, basically before an IPO is conducted, you will need to convert your preference shares into common shares. So everybody becomes common shareholders, and all the preferential rights will fall away. You need under the law itself, this is something that's flowing from the law, so there can't be an SHA of this nature with these kind of clauses in a public company. So therefore it'll terminate upon an IPO, or where you cease to hold shares, or if there's mutual consent between the parties. Those are the only three circumstances under which practically you can sort of terminate an SHA. Otherwise, the SHA continues and till the time you're a shareholder of the company. So with that, I end my presentation. These are the concepts that I wanted to basically sort of touch on. If there are any questions, happy to sort of take it now.
Yeah, thank you, Amrita. As usual, the concepts have been very illustratedly explained. This is by Srinivas Reddy. In case of an investor who brings FDI, how best anti-dilution adjustments can be worked out considering the fact that the FDI investor can only subscribe to the shares at FMV?
Correct. So that's a nice question. Usually it's done by way of adjustment to the conversion formula itself, and you adjust it at the end. So you don't make you adjust the formula, you'll probably make it 1:2. You'll basically say the preference shares can convert from 1:1 to 1:2 less than 1. And at the time when it finally converts or whatever, at that time we'll make the adjustment. So that's the most common way to do it, considering, and you'll try and also, one way of what I've also seen people do is you'll try and issue shares at a face value of more than 10. Probably you'll do it at 100 rupees because it allows you the headroom to basically issue shares of 10 rupees each or break down the face value of the shares later. There are many ways. You'll have to keep it as open as possible to accommodate the FDI related regulations, but the most common way is an adjustment to the conversion formula.
This is by Sandesh Ayam. Can a buyback by the promoter or the company be offered in an exit default clause?
Can you repeat that, Vikas?
Can a buyback by the promoter or the company be offered in an exit clause, exit default right?
Yeah, it's usually offered as an exit default provision as well. The only thing to remember in that concept, in that context, is that buyback comes with its own sort of, it has to be in accordance with Companies Act. So there are conditions under which you can do buyback and you cannot do buyback. And even it's time consuming, but it is very often, mostly in most cases, it's given as an exit default right.
Are preemptive rights same as pay to play provisions? As in, can subsequent rounds investors impose this clause on earlier investors?
It's slightly different from play to pay. People do not use play to pay. It's more common in the US, not so much in the Indian context. There is a slight difference in the two. They're not really the same because you don't determine the price upfront.
Okay. Priyank Sharma, what is the legal position of shareholder agreement in perpetuity?
I'm not sure I understood that question. Who was it? Who asked this question?
This is by Priyank Sharma. I can unmute.
Yeah, Priyank, I think you should just explain the question in a little more. Okay. Perhaps I didn't sort of understand what scenario you're looking at.
Priyank. Meanwhile, I will take off Abhinav Gupta. Is it necessary to include the transfer rights and restrictions in the articles of association of a company, or do they derive validity from the Companies Act in the absence of explicit mention in the articles of association? In addition to this, what happens if the company fails to add a particular clause of shareholder agreement in the articles of association?
Yes. So transfer rights, it's under Indian law as it stands today, you should replicate whatever you're putting in the SHA into the AOA. There are judgments which you will read and you'll probably find enforcement very difficult if you don't put it in the AOA. Like I said, the remedies differ. You'll always be entitled to damages for breach of contract under the SHA, but your rights are better protected if it's replicated into the AOA by virtue of the 3 judgments I mentioned earlier on. That's the first one. You had another question. I think what was the second question?
In addition to this, what if the company fails to add a particular clause of the shareholder agreement in the article of association?
So it basically, what happens is then if there's a breach of that particular clause which is not reflected in the AOA, you only have remedy in terms of breach of contract under the SHA. You don't have remedies that are available for breach of an AOA, which is more a statutory contract and it's under the statute. And also you may not be able to enforce some of these provisions. For example, if you read one of the case laws where there was specific mention about AVM rights, which are not mentioned in the articles, The court held that even though the company passed a resolution in violation of the AVM right, it was still held to be valid. But I think the court clarified that you can, for breach of that particular provision under the SHA, you still can claim damages. That's the consequence.
This is by Karan Garg. Please guide, I'm an investor while drafting the SHA. Is it possible that the preferential shares and special rights are provided to the investors, that is me, but we promoters cannot extend those privileges to the buyers of my shares?
Okay. This is more of I mean, I'd like to understand this question a little more. You can.
I will unmute Karan only first. Let Priyank take the question.
Okay.
Priyank, what's your question?
Can you hear me, ma'am?
Yes, I can hear you. Hi, Priyank.
Yeah. Hi, ma'am. Ma'am, actually, I have encountered a few issues wherein the shareholders agreement was there and there was no termination clause in that. So ideally, when there is a no termination clause, can we interpret that this particular shareholders agreement is in perpetuity?
Okay. So here is okay. I understood. So you were saying something. Do you want to complete what you're saying?
Yeah, because I have also get some research on that, and what I found is that the private commercial contracts can never be in perpetuity. So
okay.
So it was a big dicey thing. So I was just wanted to clarify that. Yeah.
Okay. So like I was saying, termination of an SHA happens as a natural consequence. For example, when you're no longer a shareholder in the company or you don't hold shares in the company, it sort of dies off. I think what you're trying to ask me is if I don't specifically call it out as such, what happens, right? Because you can't terminate midway. I mean, usually you don't have the normal termination clauses like in other commercial contracts for breach, etc. Because you still be a shareholder in the company, right? You wouldn't want to terminate the document that gives you those rights and obligations generally. Typically, I mean, if there is no situation where it goes on perpetually, because people, I mean, there are two documents. One is the AOA, the other is the SHA, and people who are investors will at some point exit the company. When they're no longer shareholders in the company, they will no longer then have those rights because it'll be illogical to conclude that they still have the right without having the shares in the company, right? Because the rights are associated with the shares. The rights are given to them because they were shareholders in the company. So normally, if they don't be shareholders in the company, the SHA should fall off then and there. And in my view, whether you write it or not, it's a natural consequence because it's very difficult to convince a court for an arbitrator to hold that despite not being a shareholder, they still have rights in the company.
Okay, thank you, ma'am.
Sure.
Yeah, Karan, you can post the question.
So my question is, I'm an investor and the company I'm investing into, the promoters are willing to giving me all the rights, preferential shares and all that, but they are saying whenever I will sell my shares, those rights, he do not want to transfer those special privileges to the person who will be buying from me because he doesn't know those investors.
Okay. See, Karan, there are two things here. We should have a larger discussion on this generally, but from the point of view of keeping in mind the session, the time consider two things that will actually affect your ability to sell shares, right? Because anybody who buys from an investor will be in the assumption that they get the same rights that the other investor had, and that's how it's done through a deed of adherence. So what you should do from a perspective, you should find out more information you should ask this question to the promoter and find out what are the kind of rights the promoter is not willing to pass on, because it's a natural progression that if they've already given a certain right to an investor at a certain price, the person who steps into the shoes of the investor will also get the same rights because they paid money for it. They can't come in. Why will anybody be incentivized to come into a company if they don't have those rights or the assurance that they will get those rights? So you need to understand from the investor from the promoter where the discomfort is, what kind of rights are they trying to restrict, and probably you can negotiate if there's a valid argument on certain types of right that they're unwilling to give, then you can probably consider it. But otherwise, that's a very unreasonable position to start off with, in my opinion. Okay. Very non-standard as well.
Okay, and they're also saying that for the deed of adherence that they cannot agree to that condition and all clauses mentioning the same should be completely removed from the SHA.
Not agree to this condition. Which condition?
For the deed of adherence, they do not want that in the SHA. Is that right?
It's actually in their interest to have a deed of adherence because I mean, you technically it's in both parties' interest. I mean, for you, it's important because the future investor is guaranteed, whoever you sell it to, with the guaranteed rights that you were given under the deed of adherence. And even for the promoter, I think that's probably because they're unwilling to give those rights. It's probably why they're saying there should not be a deed of adherence. But like I said, it's very non-standard position to take from a promoter perspective. You should find out and have a conversation with them on the kind of discomfort they're feeling and why they're feeling the discomfort. What kind of rights are they really not willing to give another investor? One way you could probably solve for it if you're okay, which is again pretty non-standard, but if you're okay with it, is you can run the name of the new person by the promoter. I think the promoter's concern will be that I don't have control over who you sell it to, but that's essentially how a VC transaction is supposed to work, because the investor should be given free transferability unless they're a competitor. Max to max, they could restrict a transfer to a competitor, nobody else.
Okay, perfect. Thanks. Thanks.
Yeah, I think we have no other question. I'll just check it on Facebook.
Okay.
No. Yeah. Rukmani Rao, do you see in future the jurisdiction of the arbitration becoming important given the challenges around the enforcement in India?
Yeah. Hi, Rukmini. Thank you for attending this session. Rukmini happens to be a good friend as well. So see, I mean, the way, I think one thing to understand before I get to the question is from a venture capital investment perspective, right? Venture capitalists very rarely get into a dispute situation. The reason for that is very simple, because for them, what is more important is their standing. Nobody will like to partner with a venture capitalist if that person is more dispute oriented or likes to drag the promoter to the court every time. So mostly every 99% of venture capitalists will try and sort whatever issue there is, even if there is sometimes even where fraud, etc. is involved, where they can actually solve for it, they'll try and solve for it outside of court, because there'll be investors, there'll be shareholders in the company. It affects the valuation of the company and the image of the company generally, and it affects their own investment. B, it affects their reputation in the market, because they then become investors who become, sometimes they'll be in the news for dragging a promoter into a dispute situation. So honestly, even if they negotiate indemnity, etc., as VC lawyers, all of us, it's very different compared to PE investments. But as VC lawyers, all of us are, at the back of our minds, we already know that this will probably be more a paper tiger and probably used to leverage positions rather than to actually enforce it. It's only relevant from the point of view of if there's the serious problem with the company from the point of view of fraud, etc. So if those kind of things are involved, yes, jurisdiction of arbitration is something that's important, and there's already a growing trend in this area. Most people prefer SIAC or arbitration outside of India rather than, most investors prefer that inside of India, and they also prefer the seat to be Singapore because it's efficiently run. And that's how the preference is, and that's in most VC transactions these days. You see those clauses on arbitration. Nobody really agrees to Indian arbitration, and Indian courts are out of question. Even if something has to be done because of the confidentiality provisions in arbitration, people usually take it to more efficient arbitration systems such as SIAC.
Thank you, Amrita, and to all those participants who have been connected with us for so many months now together. And the session on masterclass in venture capital documentation. I can say that the key concepts, as we rightly said, that it's a very vast subject, and to just distill it to in a 1 hour session, it becomes very difficult, but you have actually shown that it can be done. So we are all grateful the manner in which you have expressed. And tomorrow the session is on adverse possession, the shield turned to the sword, the masterclass. And we've already seen that a lot of webinars done by Mr. S. Srinivas Raghavan, advocate, who also runs another group like ours by the name of SSR down south in Chennai, in Madurai. So do stay connected tomorrow at 5 p.m. Everyone stay safe and stay blessed. And namaskar. And thank you, Amrita, once again. And to the team of Lakshmikumaran, Sridharan, who has been always kind enough to allow the partners directors to pitch in their expressions. And we are all actually enriched by that entire expressions. Thank you. Stay safe.